well some questions, but let's try to, I think what I'd rather do is hold your questions till we get to the end. The first thing you have is the updated hateful document called the Fire Hardening Defensible Space Disclosure and Addendum, and you can spend about 4 hours on this alone, but I'm here to talk to you about the change that was made to it. If you remember in the fire hardening section, if you look at paragraph 2B, there's some things for the seller to disclose if he knows whether or not, you know, are you aware of if any of these vulnerabilities are there. Things, of course, that would make it easier for the home to burn. So what they did in an update in this form, what the state did, the state now requires that the seller, on the flip side, gets to disclose what the seller did to actually make the home less or a little more fireproof. Let's just put it that way. So these are the positive things that the seller may have done. And in most cases, the seller has no idea what these things mean. And that's okay. That's a no answer. Okay. I mean, to go over these, that's all it is a list saying, hey, did you complete any of these? And if you think you completed one, if you didn't think you started, or you thought you started it but didn't complete it, then you explain it on the top of the next page. But these are things like roof replaced with Class A fire rated roof. Typically, I think when you would replace a roof today, especially if you're using a contractor, you're probably gonna have that. Installation of non-combustible gutters, install ember and fire resistant vents. That's all this stuff. And basically that's it. The seller's just gotta go through the question and answer yes or no. And the only modification to that is if the seller thinks they started something and maybe didn't complete one of these, and maybe they can explain that. So they gave an explanation section for it on the next page. That's all they did with this, is just add these in. These are not requirements. The seller doesn't have to do this. The seller just has the ability here to brag about how he made the home more fire hardened, shall we say, huh? Okay, that's that simple. Okay, we're gonna go into now a discussion of the difference between amendments and addendums. Now, forever, up until recently, most of us have sort of used the term addendum and amendment interchangeably, and they're really not. You know, basic contract law is an addendum is something that when you're forming an agreement, you attach an addendum as part of it. An example would be you're writing an offer, and there's a huge list of personal property that you want. So you attach an addendum because that's when you're forming the contract. Once the contract is signed, once we have an acceptance, okay, thereafter, if you're going to change any of the terms, that's an amendment, okay? And so a change to an existing agreement, or let's say a change to an already disclosed item, like a TDS or an SPQ, those are amendments because you're changing something that's already been done, okay? So that's the difference. And so therefore you've got this several new forms. The first one's not new. We've had the amendment of existing agreement terms. Well, what have we did this before? Well, we're in the middle of the deal and we make an agreement that there's gonna be a $5,000 credit to the buyer, right? Okay, amendment. That's a change to the existing contract. So that's your amendment of existing agreement terms. And see, it's got like an offer and acceptance setup. Okay, different from an addendum that just, well, everyone's gonna sign below and that's it. Well, here they give the other party, whoever's offering this is giving the other party 3 days to accept. and then it's taken away. So that's it, pretty simple. Again, this is a change to an already existing contract. What about disclosures? Your next form is called an amendment to prior disclosure. We finally have one of these. We've seen partway through, the seller says, I forgot about this. Okay. So this is an amendment to a prior disclosure. It's either an amendment to the SPQ, you check the box on top, or the TDS, or both, or some other disclosure that might have been given that you're modifying. Okay? That's an amendment to a prior disclosure. So you just have to keep straight which forms to use. All right. Addendum, when this is, again, this is the basic, boring, vanilla addendum that we have. On your next page just says addendum, number blank, ADM, okay? That, again, this is when we're forming a contract, a lease or a purchase, okay? And now we're going to attach to our offer or counter offer some additional terms. Again, this would be used then for your list of personal property you want to include. Got a long list. This is an addendum because this is part of either your offer or counter offer. We don't have an acceptance yet, so it's an addendum to something we're trying to agree to. That clear enough on that? Okay. The next page is, and I have no idea why they named this addendum generic, because it's specifically for when you're forming either a listing agreement or a buyer representation agreement, and you have some additional terms that are not in those forms, and you're writing it up, okay? You haven't have the signatures of both parties. That's an addendum to either one of those documents. So this is between the brokerage and the client.
That makes no sense, though.
What part doesn't make sense?
That they put generic in the headlines.
I don't know that. That's what I said. I have no idea why. But that's what it's for. Okay, so let me try to come up with an example to this. You have a listing agreement, and the seller has given you some special instructions of some kind. And this is before you've already executed. This is before you've executed the listing agreement. You're preparing it, and you need a lot more room. And instead of using a text overflow, you use this. You could use either one. Okay, and so you write in here something like whatever the seller wants. He wants to make it very clear, you know, nothing after 5 p.m., whatever the things that the seller specifically wants. And this is part of an addendum. And let's say you're in a buyer representation agreement, you're preparing that, and the buyer has certain things that you know, they want you to be sure that you're looking for them, and if perhaps, even though there's some, that's an example, but there's actually some space in the buyer representation agreement for some of that, but you never know. You may have some unusual situation where they want to, you know, get into something a little bit, something more than is already written for you in the standard form. So this is, again, you're forming a listing agreement or you're forming a buyer representation agreement. And that's what this is for, specifically just for that. Once you have an agreed upon listing or an agreed upon buyer representation agreement and you're modifying it, we have those forms separate. There's a little note there in bold. So if you've got one of these and now you're changing it, okay, you're modifying, let's say, the commission amount, or you're extending the term of the document, whatever it is, listing, buyer representation group. Then you use CAR form MTLA, that's for modification terms listing agreement, okay? This is a modification, or a modification terms BR, buyer representation agreement. So those are forms that you would use once you have an agreement together signed, and now you're modifying it later. So use those for that. So that's like 7 different forms we've looked at, all depending on what the situation is. So we just look at the facts and go from there. The next 2 documents are very, very unusual in that I don't think they were really necessary. So, okay, we have an additional signature addendum, and let me explain this. This is only when you're forming an agreement. Let's say you've got a listing agreement and you have 16 sellers on title, right? And, you know, there's only a couple of lines for signatures. So when you're forming the document, purchase agreement, listing agreement, lease, whatever it is, and there's just too many, you can use this. And then you check the box, number 2 is to purchase. Here's the documents we're using in the purchase agreement that you're all agreeing to by signing this one document. This is not what you do later when a buyer or seller, a buyer is added or taken off. That's an assignment. That happens afterwards. This is when you are forming the agreement and you just got too many signatures to deal with. So that's what that's for. Otherwise, for example, if you're partway through a transaction and you're gonna add on 5 buyers, you wouldn't use this form. You would use an amendment to existing terms, the AEA, because you're changing it and it's not designed for that sort of thing. And you're adding it, and that's an assignment too. So it's sort of a cross between your assignment form or the amendment of existing terms. You can just use the assignment form. Sorry, I take a step back from the amendment of existing terms. If you're adding a bunch of buyers or taking away a bunch of buyers or adding sellers, that's more in the form of an assignment. And again, this document is used when you're putting the transaction together, whatever it might be. Having said all that, I've seen practice where you can get on DocuSign, for example, multiple signatures in the same spot, you know? So I kind of question the real necessity. There's no law that says, you know, you can't have 2 signatures on one line, okay? Or 3 or 4, if you can read them. So, I don't know, is this really needed? Who knows? It's new, so it's revised actually, so I had to put it out there. Okay, same thing for liquidated damages and arbitration. Those provisions have to be initialed, right? So, if you're forming a purchase agreement and you've got, 16 sellers or 16 buyers, and they all have to initial this either in the offer or the counteroffer for these things to be included. So it requires a specific initials. So there's initials for liquidated damages, and then a separate set of initials for arbitration. Again, that's what it's there for. So, again, I think you can get on the same page in the purchase agreement that contains liquidated damages and arbitration, right? Can't you just plug in a bunch of these? I don't know, I think so. I've seen that many times, I don't know. I think they're maybe a little over the top in this one line, one signature, or one small line, one set of initials, I don't think that's necessary. Okay, they modified, the next document is a referral fee agreement. Okay, so you're referring somebody, perhaps out of state, whatever it might be. They added a section. Well, first of all, the broker that's going to pay the referral fee, that's the one who's getting the client, right? Well, they're called the representing broker. If you look down at the bottom, there's a referring broker and then the representing broker. Representing broker simply means that's the broker who's gonna end up with the client, the buyer or the seller, whatever it might be, right? The other thing that they did was, if you see in just paragraph 1, there's the referral fee, there's the amount. If you look at B, you're now identifying what this client wants to do. Check box, buy, check box, sell, whatever this client is intending to do. And that's important because, these things are good for like 12 months, right? So what if the client you referred not only bought, but also sold, and maybe you think that might happen, so you wanna check both. So you get referral fees on both of them. I mean, that's one reason for that. The other reason is number two. Let's say you checked buy, and 2A, it defaults to 2A and says only the first purchase, only the first transaction, that's what I'm getting paid on. Or that's what I want, or the other, yeah, that's what's negotiated. B says, if you check that though, it says just for the following properties. All right, and C is for anything that happens. As long as it's a buy, if you check buy and sell both, and, you know, so that's the change. So I think that's fairly understandable, yes? So, okay. All right, the next two documents are advisories. So, no thinking involved here, just delivering, okay? You get signatures on the document. These are advisories. The first one is the rental property owner advisory. Anytime you have a landlord or tenant client, this is sort of a, take that back, this is really just for the landlord. For the landlord, and the tenants can be given one too, but this is kind of a California landlord-tenant law in a nutshell. That's what these pages on this advisory are about. Talks a little bit about state rent control. It talks about the maximum deposits security deposits that can be charged. This is a whole bunch of information, taking photographs before, and then after again. I mean, all these new requirements, and we had several new requirements that came up this year in landlord-tenant law. It's constantly changing. So what they did was they thought they put together sort of the basics of what landlords and tenants deal with. And it's mostly these are mostly requirements of landlords. And that's why it's sort of designed for the rental property owner. The rental property owner would be your client, unless it's a buyer who intends to become a landlord. So the buyer is buying income property, right? So you want to give this to your buyer so he knows what he's in for, right? Because this is California, you know, the home of very complex landlord-tenant law, and lots of it. So I think this is something, and I really suggest that everybody read this, okay? So you have a place you know where you can go to, because you're going to run into these kind of questions, and a lot of them are answered right here. I thought it was very helpful. The last document is another advisory, and this is kind of unique. Okay, let's sort of set the stage for this. You have a seller, and you've negotiated with the SIP form, seller in possession. So your seller is going to hang out and stay in the property for anywhere between 1 to 29 days after the close of escrow. You gotta use the SIP form, because just writing in there, you know, close of escrow plus 5 days or something, you should use the form, because there's too many issues that come up that aren't explained in a one sentence. So using the SIP form, this is advisory to the seller in possession form. So the purpose of this is to sort of explain to the buyer and the seller that what we're trying to accomplish with a seller in possession for less than 30 days is we're not trying to create a landlord-tenant relationship. That's why it's called a license. So the seller in possession license agreement, it's a license to stay, not really a landlord-tenant agreement. We don't have a lot of case law or anything else that gives us a lot of guidance. So you'll find in looking over the seller in possession advisory that both the buyer and seller should acknowledge receiving, so they understand some of the issues that come up when you have somebody who's living in the property who's not a tenant, the seller, and somebody else owns it, the buyer, and these are a number of the issues to take a look at. And that's One of the issues that's kind of interesting is insurance, you know? If I were the seller who's remaining, maybe I'd like to maybe I wanna talk to my insurance agent, especially the buyer would wanna talk to insurance agent, because he now has somebody else living there. The other thing the buyer may wanna talk to is the lender. You know, some lenders don't allow that at all. I don't know how many, most of them that I've seen, require either 30 or 60 days. Buyer's gotta be in there if it's a owner occupied loan. So, so these are just a whole bunch of things to just, for them to consider, and kind of explaining the concept of a license versus a landlord-tenant relationship. Again, there's all kinds of little things in here about the security deposit, whether or not you really want to do that. They raise the interesting legal question of, if you have a security deposit, isn't this looking like a landlord-tenant agreement now? Again, we don't have a lot of guidance in the law as to this whole license concept. But, you know, I think although buyers would like security deposits, they're discouraged. And the reason is the buyer doesn't really want to create a landlord-tenant situation to have to comply with everything. I mean, for example, habitability. Well, what if you're buying a fixer-upper and half the stuff doesn't work in the property? Now, as the buyer, while the seller is in there, you're gonna have to fix everything? Well, that's what you'd have to do if you were a landlord, right? So the idea is we want to stay within this license concept. So therefore, a security deposit is discouraged. I think the buyer is risking a lot more in having a security deposit, making him look more like a landlord.
Right.
And we really don't want that. So I think they're better off without it. It talks about this in here. You don't even have to try to come up with this, being a pseudo lawyer and kind of going through that. It's explained, you want them to read that, and that's about it with this advisory. It just covers a lot of stuff. I encourage you all to read it. Somewhere along the line, you're gonna have a seller who's staying. I think this happens often, and we wanna encourage the use of the seller in possession license agreement, the SIP form. Okay, well, that's my form presentation. Go ahead. What do you got? Questions? Yes, take your time.
On the rental property owner advisory, is that just for, that's not commercial, like, retail rental, like, not a lease or?
No, this is, the advisory is primarily residential, yes.
I got a question about the seller, the SIP form, seller in possession.
Right.
It takes, 2 pages and then a signature.
Yep.
With a lot of great information, but
Yep.
it seems to be confirming the number of days that is listed elsewhere in the, agreement. Is that
Okay, are you
correct?
referring to the advisory or the actual SIP form?
I guess the advisory. So the
Well, the-
advisory just hey, just so you know kind of form.
Yes, that's exactly what it is.
Okay.
It's something they want to read before they execute a seller in possession license addendum. Yeah, good question, yeah. Take your time, I'm here. Kind of a,
Vince, in the
Essential
additional
question.
signature addendum and
yeah,
the form after that, the liquidated damages, arbitration additional signature addendum. You gave the example of having 16 buyers.
yeah.
So we have 4 additional signers on these forms, so we use 4 of these? Do we number the buyers consecutively up to 16
I think you just
instead
use
of?
DocuSign and just try to
instead
fit
of-
them all in, is what I think, but, well, I see what you're saying. There's only so many signatures they give you.
Yeah, they do give
On,
you
on,
enough.
on this as well, you know, they add in, I guess, so you've got A, B, C, and D, and you're waiting for the next page and the rest of the alphabet, right?
Right.
So,
Or can
Yeah, you do a couple,
can
you do a couple of these.
Attach an
So
addendum.
16, I guess well, you'd have 2, you'd have 3 of these, and maybe 4 of these, because 2's on the contract, and, yeah, something like that, yeah. Just do the math on that, yeah.
Yeah, so, the amendment to prior disclosure, so.
Yes. Amendment to TDS or,
Yeah,
yes.
right, you've already had the disclosures filled out when you took the listing, and then there was a lot of repair work done. And so I would use this as an amendment to the prior disclosure. No?
Well, wait a minute, no, it's only an amendment once you've sent it out and got signatures on it.
I've gotten signatures of the sellers, I haven't gotten signatures of the
You
buyers.
just redo it then.
Just redo it?
Or do an addendum to
Or do an
it.
addendum. Okay,
Because,
okay.
again, this is the formation of your
Right.
disclosure, you're not changing something after you've received signatures back, after you've sent it to the buyer's
Okay,
agent.
that's what I was gonna do,
That's-
so.
yeah.
I saw this and I was like, ah.
Yeah.
Okay, so even though the dates will be different, because the sellers have already signed it. And then on the addendum, it'll be a new
Yeah,
signature.
right.
That won't then rescind, it won't give.
No,
back-
no,
okay,
it's an addendum to that. The other way of doing it is just redo the form.
Yeah.
I mean, if there's that many changes, it may be more cumbersome, I don't know.
Okay,
Because if you do an addendum to it and then you're gonna be really careful if you're not typing in something that may specifically conflict in a way that was not intended.
right.
So
Okay.
I think redoing it makes more sense in your situation,
Right.
yeah.
On that same form, the amendment to prior disclosure, they still have 7 days, right? When you have a new disclosure.
It's not 7 days.
Well, it's whatever days
Yeah,
that's negotiated.
it's typically 3 days by email. It's 5 days in regular mail to terminate. 3 days if handed personally or if emailed. Okay, so that's, in fact, usually they state that. And it's on the actual TDS that you'll find that language, if there's an amendment to it. Yes, that does, any kind of material change to a disclosure afterwards is gonna trigger that right of termination. That's correct.
I have a question from our TC, Ani. She said, regarding that fire hardening disclosure.
Yes, yeah,
If we are on the listing side and it's a high fire zone.
yeah.
Which boxes do we check regarding section 3? I guess
Oh,
we're getting tripped up on that.
Okay, all right, that's,
There we go.
okay, this is what requires a lot of time. Let's first of all, this is really not supposed to be your problem. Okay, this is supposed to be filled out by the seller, which is why they give them this whole thing, this 2-page document is for the seller, the decision tree thing. Okay, if you go through it, and I went through it very slowly, it does work, okay? It does make sense, but it's complicated. And, the problem we have is the seller has to find out if there is, this section where it's problematic in that you have to now find out one way or the other if there is a local vegetation ordinance or.
It's very hard to find out. I dealt with this one time recently.
They-
And nobody knows anything about anything, including the numbers on here that you call. They have
No,
no
well, see,
clue.
they give you in this top right-hand box of the first page, how do you find out if your property, if the subject property
I
has a
called them.
local sort of requirement, okay? And then it says you can contact your local fire marshal, contact CAL FIRE, or contact your natural hazard disclosure company. I have been suggesting to people now, ever since this came out, that you talk to your reps and say, we want you to identify if there is a local vegetation ordinance as part of these long disclosures. Property ID is one of the most complete I've seen some pretty good stuff in my, and I'm not trying to solicit, but I'm just saying, some of the better ones go into a lot of detail. And I think I only found one that actually identified a local, even had that on a list of things for them to check on. So this is something that's gotta be done on kind of the industry level, and that means all of you talking to your reps to try to get them to identify that. And the second thing is, once you identify, if there's some special local vegetation ordinance, whether or not it has to be completed prior to the close of escrow, that's a point of sale requirement. I can tell you right now, right at the moment, there isn't a point of sale requirement in the cities in Southern California. Okay, meaning the buyer simply has to complete whatever the local vegetation ordinance requires at some point. The state law gives 1 year to comply with the state, okay? Local vegetation ordinance could say anything, but we know right now that none of them require the seller to come up with a compliance statement prior to the close of escrow. There's a real misunderstanding about that. And that takes the pressure off figuring out, trying to figure out if I have to run out and get some sort of compliance investigation, and that really isn't necessary. However, there's so many different boxes and choices here. Certainly the buyer and seller can agree that they're gonna do that before the close of escrow, or that the buyer is going to set that up and pay for it, or that the seller is, that can all be negotiated. I think that, again, the most important thing to understand right now is there's two kinds of laws out there. Generally, there's all kinds of maintenance laws, right? Every city has got all kinds of laws that affect owners of property, okay? Well, the local vegetation ordinance is just one of them, but they aren't necessarily tied, as far as I know here in Southern California, to the sale of the property. They're just general requirements. The state, however, does have the requirement that within 1 year of the close of escrow, assuming the buyer and seller agree on that the buyer will take it over. The state is fine with giving the buyer a year after the close of escrow, which is why you'll notice on the second page, number 3, the first thing this thing sort of defaults to is 3C, buyer and seller agreement regarding which party shall obtain compliance with applicable state or local defensible space requirements. Number 1, it says it's the buyer's responsibility. 1 year after the close of escrow. Now, that you can agree on any of the other boxes, okay, but it defaults to that one. And that's because, well, this was written for the real estate industry. We don't necessarily want to have more entanglements than we already have right now in trying to close a transaction. So that's there for you. I know there's a lot of boxes here to check, there's a lot of questions, but the main thing is trying to identify if there is a local vegetation order. The seller has, this is the only law that we're aware of where a seller has to identify if there's a certain maintenance law floating around there regarding vegetation. This is all because of the fires, previous fires, and the worst one we've had here.
So the referral fee agreement, do you then recommend that rather than having the agent that we are referring to in a different state use their own form, do we have to use this one?
I don't know any form is fine as long as it complies with the complexities of California law on this. And this one does obviously conform. I can't tell you if there's another form that necessarily complies with the requirements of the state of California without looking at it.
Okay.
And then
So
probably
it would
spend
be
a
better,
year on it.
it would just be better to initiate it.
Well,
on our
again,
end.
this is intended to be part of the offer and counteroffer. This is some things to negotiate, okay? So, and the hardest part of this is for a seller to have to look up if there's a local vegetation ordinance. They give some places where you can do that. And, you know, as an agent, you can take the position that, look, and it's a very fair position, this is a seller obligation, and leave it at that. So if you're representing the seller, that's a very difficult thing for you to do, right? So you end up doing a lot of extra work that the law does not require of you. Okay, I mean, there's a lot of us attorneys out there that don't like the idea of agents trying to find laws. So we're hoping that the natural hazard disclosure companies, that they could be pressured by enough people in the industry to start identifying these in whatever city that we're talking about, so.
Okay, I'm sorry, Vince, I jumped onto a different form.
Oh.
Yeah, I was talking about,
Oh, I'm sorry.
a different form.
What?
If you're not done with that one, I'm sorry.
No, yeah, that was
Yeah,
it.
okay, so
Which-
the referral fee.
Oh, the referral fee grant, I'm sorry. You were saying if another, state has their own,
Yeah,
it's fine, it's a contract, as long as it covers what you want covered.
okay,
This goes into a little more detail because we've had arguments in the past that, you know, I referred a seller to you, but I didn't know he had 2 properties to sell. I want commissions on both. But if you let it go to the default on this, you're only getting the first one to close. And if you wanted to cover yourself, you may want to check the 3rd box, say anything, as many as they find. Or is that the second one or the 3rd one? And then there's one that just identifies a specific one. See, for example, if I'm now gonna be the representing broker or the receiving broker, I'm gonna wanna limit how many referral fees I wanna pay out. So you're on different ends of this, and you just have to look at it from that position and see what best applies. But yeah, there's nothing wrong with an out-of-state form for a referral fee agreement. They're using ours, we use theirs, you know,
okay.
it's fine.
Are we required to use the addendum generic now instead of just basic, regular addendum or whatever?
Again, it all depends on what we're talking about.
Cause you said that one was for specifically,
That's specifically for the listing
like a listing
agreement?
agreement or by a rep.
Right, and that's only when you're forming it. If you're
Yeah.
changing the terms
No,
afterwards.
I don't mean changing, I mean
Okay.
like an addendum, like the basic addendum that's like, oh, addendum number 1, which is what.
No, you're supposed to be, it's because of the signature lines. If you look at who's signing, okay, the one for, the one that's called generic, that's between the brokerage and the client, you'll see down below, you've got principal number 1 and 2. The reason for the principal numbers is because the principals in a listing agreement are what?
Oh, I see.
The
So it
seller,
doesn't have anything
the
to do
principal
with
is actually the
party.
seller and the brokerage. They're the principals in the contract. They're the parties essentially, and that's why they line it up like that.
So for principal 2, the agent would sign there.
Well, pardon me?
So regarding what you just said, for principal 2,
Yeah,
we want our agents signing there.
yeah, on behalf of the company, yeah, all right. That's the way I interpret it. So, you know,
So,
I mean, again, I don't know how often this even comes up, because this is, again, you're putting together a listing agreement or a buyer representation agreement, and, there's additional term boxes in there already, and if you go over, you're on a text overflow addendum anyways. I don't even know why you would need that, I honestly don't. It's just a little, they generate sometimes a few more things than we really need. I guess that's the best I can tell you. I'm not trying to put down the form committees, but, you know.
would this possibly be an instance where, and I need to talk to Ken about this too, but, my seller, you're aware of, with the legal background, said that I have to sign something, in order for it to be valid to use arbitration and mediation, which it does say in there that the agent can agree to arbitration and mediation in writing, but there isn't a place on the actual contract.
They've taken away the arbitration section of listing agreements. They left in the mediation section between the brokerage. agent and, the seller.
It's not clear in there, I guess. It says,
It
well,
doesn't,
it,
I don't have
Yeah,
one
I
in front of
know.
me, but
You know what, and maybe
there's a
maybe
mediation
it's the-
section. Mediation doesn't have to be, quote, initial, that's what people think.
Right.
Only arbitration and liquidated damages things by law require separate initials for residential 1 to 4.
okay. But
Okay,
if you wanted me to sign something saying I agree to mediation,
it's already in there, you know what? Oh, look, if the
You know
attorney
what it is.
can't see what it says just that. To write it all over again, yeah, if you want to, say, yeah, I agreed to paragraph 15 above mediation, sure, you can do that.
and it would be
It's
this
just,
one.
it's duplicative, it's redundant, but yeah,
Okay.
so we do a lot of redundant things here. So, yes, and then we'll go,
So what is the difference between the amendment of existing agreement terms and the addendum?
I went through that earlier.
Yeah, but I think a little.
Oh, okay. An addendum is when you're forming a contract. Once you have the signatures from both parties, that's when you need an amendment. That's the difference.
The amendments are the ones usually that the escrow company prefers.
Escrow companies do amendments because it changed to their initial instructions, typically. I don't see two,
So I don't know, because usually the amendments are done by the escrow, so.
no, you need one for your contract, and you can
Okay.
send it in. You can send in your credit of $5,000 on the amendment form to escrow, and then they use that, and they create their own, because they need their own instructions signed.
Oh, okay.
So, it's not a duplication, one's for the parties, the other's for the escrow to follow the instruction of the parties, yes.
So on the fire hardening defensible, what if it's, there's a tenant in there and you're going to sell the property? And the landlord is not local, so how does, like, if you're not aware of, all these things?
Okay, they want to remove a tenant in order to sell the property, is that what you're talking about?
Yeah, so there's a tenant in place.
They have to fall, there's local rent control that makes it very difficult to do that, and then there's state rent control. And there are ways of doing it, you gotta refer them to a landlord-tenant attorney, it's not something that you could advise them on. Okay, there's too many issues, guys. There's too many issues in trying to comply now with the multitude of landlord-tenant rules when it comes to default and non-default provisions, whether or not you've got one of the few conditions that allow a landlord to just remove a tenant. There's just a lot there. On a single-family dwelling that doesn't have rent control and the owner is not a corporation, okay, then, and they received the RCJC form already and the box was checked exempt, then it's just a regular 60-day notice, okay? But other than that, if state rent control applies, it gets much more complicated. Even more complicated if there's a local rent control, and that's when you refer landlords out to landlord-tenant attorneys. You can't advise them on that. Any other questions?
Then, quick question. On the fire hardening disclosure in section 2, it says properties built on or after January 1st, 2010. So if your property's built before, you don't have to fill out sections 2B and C?
Yes, if the newer properties, the fire hardening has the fire hardening section, not the defensible space section, but there is an exception for properties that are built after January 1, 2010. That's the newer properties. Newer properties are exempt from the fire hardening section, okay, but not exempt from the harder section of this, which is this defensible space section.
Okay.
Does that make sense? Okay. And that's the difference between when does the fire hardening section apply, when does the defensible space apply. They typically always apply at the same time, except if the property is new, January 1, 2010 or newer. Okay, and that's when You don't need fire hardening section, but you do need the defensible space section. That's what they're trying to explain in those opening paragraphs about when you use this form to begin with. Okay. Okay, unless you have anything, have a great day. Thank you for your patience.
Thank you, Vince. We appreciate you as always. We have food for you guys provided by Joe. You want to come up here? Cut and Dry. And while he's coming on up here, I just want to remind you guys, I don't think this is news to anybody, but there was a terrible flood disaster in Texas. And the difficult irony of it is those market centers that are affected are the very market centers that sent money to us in January. So it is now our turn to return the favor. We have some information here, ways that you can help. We are gonna have a QR code as well. I'm all about making it as easy as possible to donate. So there will be a QR code coming where you can simply Venmo the funds to that Venmo account, and then we'll turn around and buy gift cards to send over there. But you can see right here, cash check we can charge to your account, or if you want to give gift cards, Walmart or Amazon are great options as well. So we're gonna be talking about that for as long as we need to, because they need a lot of support right now. It's been a horrible disaster. So take a look at those flyers that are floating around. The QR codes will be around there as well. So now that I've brought the energy and the mood way down, Jewel, help me out.
Thanks, Gabe. My name is Joel. I'm with Cut and Dry Restoration. I'm sure you know a lot of you are pretty hungry right by now, but I did bring some lunch for you folks here. But just want to remind you folks, I see a lot of new faces here. You know, we focus on water mitigation, mold remediation, fire, smoke damage, anything like that you might come across, vandalism, board ups. We go out there, clean up the glass. You know, if you have any commercial clients or even residential, sometimes, you know, there's break-in, smash and grab situations. But just wanted to be here, remind you folks of, you know, the partnership that we do have with Keller Williams Pasadena. We appreciate your partnership. Hoarding situations, you know, there's situations where you go into a vacant property and maybe there's squatters that have been there. We can go in there, clean it all up, sanitize it properly. So, you know, just keep us in mind. My cards are right out there, right by the lunch. So feel free to grab one. If you have any questions, feel free to reach out to me. And then, you know, we appreciate, again, your partnership and hope to hear from some of you that come across any situations like that.
When you say hoarding situations, you go in and clean it up.
Yep.
You take all the stuff out.
Yeah, we'll clear it all out. Anything that, you know, that's, you know, no longer anybody's personal belongings, we'll go in there, we'll clear it all out.
Can you deal with the insurance company?
We work